And I would love to have interactive sessions. In case if you have any questions, you can post those questions anytime, anywhere, and I'll be happy to answer them. I'll be happy to try to answer them. So let's start here. We go to the next slide. Yeah, before we go further, it's my quick introduction. I think Prab already told about me. I work for Microsoft as senior program manager for cybersecurity and data privacy domain. After this webinar, also if you have any questions, or we can also get connected socially on LinkedIn, and we can have more things to share in the future. So this is my LinkedIn address, and you can send me the request, and I would love to accept them. Here is the agenda of today's 1-hour GDPR webinar. First, we'll be talking about GDPR and its terminologies and concepts. It's all about law, so we need to really understand their terminologies and concepts. And then we'll also have to talk about scope of the GDPR, the material scope, the territorial scope. Then we'll go further to talk about the principles, the data processing principles that GDPR enforces. Then there will be a very interesting subject that is called data subject rights. So we'll talk about what is data subject in the terminologies and concepts, and we'll get the understanding about what data subjects, and then we'll talk about data subjects rights here. Then we'll talk about supervision and enforcement, how the GDPR is enforced across the world. And then we'll also take an example of GDPR loyalty card example, which will actually explain us how we can implement the GDPR in the real life scenario, in the real world scenario, I would say. So I think we are ready to go, right? Let me start. Yeah, quickly, I have this date here on this screen, and I would love to hear from all of you. Do you know about this 25/5/2018? What actually it donates? What actually it represents? Any idea? Great.
It is a date. Yeah, it is a date by which all the companies across the world, especially managing data of personal from US region or across the world where the data is handled, should be or must be complied to GDPR regulations.
Great, Srinath. Yeah, Srinath and Anuradha. Yeah, exactly. This is the date when the GDPR enforced across the world. All the companies across the world, we'll talk about this in the territorial scope. All the companies across the world, those are processing European nationals' personal data, should comply to the GDPR on or before this date, because this is the date when the GDPR got enforced across the world. So we are living in the era of GDPR. GDPR is now active, and if we are not compliant, then we should think about how quickly and rapidly we can comply to this regulation. Let's go to the next step. When we talk about GDPR, GDPR is all about privacy. It's all about data privacy. Yeah, and when we say privacy, do you guys know, I mean, to be some fair idea you should be having it, that privacy equals to what? Any guesses, any normal guesses? If you have any normal guesses, like when you talk about normal privacy, privacy gives us what actually? Yeah, the right to be forgotten. This is Sanjay. Yeah, this is of course one of the data subject rights. We'll talk about it. Okay, so there is only simple term here. Privacy equals to freedom. If we have privacy, we feel we are free. Nobody is tracking us. Nobody is monitoring us. You know, in our workplace, if our managers are doing the micromanagement, we don't like it, right? So privacy is all about freedom. This is how actually world explains the privacy. And GDPR is all about privacy. Um, I included this slide to give you the early understanding of GDPR, to look at GDPR from 50,000 feet angle or 50,000 feet distance. So when we talk about GDPR and we look at GDPR from 50,000 feet, and I will get this picture. You know, it's very simple. It's very simple. It's nothing new. All about, you know, this all now, you know, we can understand this in this slide. GDPR is all about personal data. We'll talk about what is personal data. And when we talk about personal data, what data, you know, we should know this because it's all about personal data. So if we need to comply with it, we should know this, that what data we have, what personal data we have in our organization. If we get that answer, then the next question should be where you have it. We should have the inventory of that personal data. Somewhere we should know that, okay, we have this personal data and it is stored here. So we should know the location of that personal data. And once we have that location, we have the inventory, then we should ask the question why we should have this data. Do we really require it? If we don't really require it, why should we keep it? Why should we take unnecessarily risk there? So we should ask those questions, and then at all we find that, okay, I need this data, it should be there. I mean, I should have required this to be there in my inventory because my business requires it. Then there will be another question that, okay, then we should think about it, that how we should use it. And this all answers GDPR gives us in the regulation. And GDPR demands simple things from the organization. It should be, the demands are, the organization should be ethical, transparent, and accountable for the personal data. Whatever they do with the personal data, they should be ethical, transparent, and accountable. It's a language, it's an abstract language, it's a language of law. So, you know, so we should understand this in that terms only. It's not something a Boolean algebra where we can say that 0 or 1s, yes or no. No, it's all about what we can say, what, you know, the at that point or situation, what is true, what is ethical, what is transparent, what is accountable, that all we should take a call at that point in time. So this is all about the 50,000 feet introduction. Then let's talk about here about some of the quick points on GDPR. It's a general data protection regulation. It's applicable to all EU member states. All 28 EU member states are following this regulation as of today. And it's another terminology here is it's one-stop shop from EU to the world. So if we deal with the clients from Germany or UK or Belgium or Italy, any member state, the law will be the same, the regulation will be the same. There is no difference. Okay, then of course it applies to the personal data. Earlier regulation, we'll talk about it, the DPA was there, but why we should require the GDPR at this point in time? We'll talk about this in the next slides. When we talk about regulation, it has 173 recitals, followed by 99 articles. And the recitals are actually the clarifications or explanation of those articles, and articles are nothing but the wordings of the regulations. So articles, as they are the wordings of the regulations, they are very likely to get changed in the future, but the recitals will definitely get changed, or get many things will get added into the recitals as we proceed, experience different cases in the courts, and then the judgments will get delivered. So based on those basis, the recitals will get expanded, will some more informations will get added there. If you have any questions, or we'll proceed further. Yeah, so yeah, there is one important point here that we should understand. GDPR is not a new law. It's something which is not a very new thing to us. It is actually the harmonized, modernized, and strengthened revision. It's a revision of Data Protection Directive of 1995. So we used to have this Data Protection Directive. Now we have a regulation. There is a directive that we used to have. Now it is, the directive is got converted to the regulation. So we need to understand what is actually the difference between directive and regulation, and that's where it's a language of law. But for us to simply understand this, that directive, when we talk about directive, directive is the set of rules that must be elaborated and ratified as a law by each member state. But the member state can take a call to understand and create their own terminologies in the directives. But regulation is actually a harmonized version of the law, which is not necessarily elaborated. But in very particular cases, regulation may give some freedom to the each member state for to add something. Like, we can talk about one point where the GDPR is not applies to the deceased person, those who are died, but it gives the freedom to the member states, if they have any as such privacy laws for the deceased person, then they can include that as part of the GDPR. But it is not necessarily that we need to elaborate the regulation to all the member states.
Shanavas, just need to understand from your end, like, what was the purpose of doing the revision of Data Protection Directive with GDPR? What was lacking in the
Yeah,
Data Protection Directive which make to introduce of GDPR?
yeah, that's a great question, Prab. So they are, yeah, so there is one thing that we at this point of time we require it is modernization, because in 1995 we were not having iPhones, no Facebook, we were not having so many other social interactions like WhatsApp, LinkedIn, and all. So nowadays our personal data are being shared across the world, and our cybersecurity threat landscape is rapidly evolving. So it's a need of the hour today that we should modernize the 1995 directive to create some regulation which actually applies to the current situation. And that's why the GDPR is the DPA got revised, and GDPR came into the picture. And it is also, there is
Okay.
another point here that, yeah, that it there was a need that, okay, there should be a harmonized version of a privacy law across the European state. So DPA was there, but every member state was having their own terminologies to explain and understand the data protection directive or act. But GDPR is actually harmonizing this across the member states. So we, being in India, we have a company and we are processing the personal data of European nationals, then we should not think about how we should deal with the clients in Germany or or UK or Belgium, because GDPR is same across all the 28 member states. It was not the case before. with GPA or Data Protection Directive. Prabhu, I hope I
Yes, yes,
answers the
yes, yes.
question. Yeah.
Thanks.
Thank you. Yeah. So let's move forward. We'll talk about what is personal data.
Sorry to
Pers-
pause you. Sorry to
yeah.
pause you here. I also heard that any data pertaining to a person who is not alive. Is there something GDPR says that even after the demise of the person, the data has to be protected for n number of years or so?
Okay. So uh, as a common regulation, GDPR says that GDPR doesn't get applies to a disease. When a person is died, the regulation is not applied to him. But at the same time, the supervisory authorities have given the control to each and every member state to take their own call if they have their own ways or privacy laws for the disease. Then they can take their own call to create their own uh, uh, articles there. So for diseased, the common understanding is GDPR doesn't get applies to them, don't get applies to them. But then we have laws in France, we have laws in Italy. They talk about the personal data of deceased. So GDPR respects those laws, and those laws, as part of the compliance, we should comply those laws if that member state has those laws. If that member state doesn't have any law for disease, then GDPR as a common doesn't get applies to disease, only for the living natural person. I hope this answers your question.
Yeah, thanks.
Thank you. Thanks. Yeah, so here we have a personal data definition. Personal data, GDPR says personal data means any information relating to an identified or identifiable natural person. There are 4 building blocks in this definition. Any information is one building block, relating to is the second building block, identified or identifiable is the third building block, and natural person is the fourth building block. Let's talk about those building blocks to understand what is personal data. Yeah, so here we already discussed this. We have 4 building blocks: any information relating to identified or identifiable natural person. Here we have the first building block, any information. When GDPR says that any information, it literally means any information, whether it is explaining the nature, content, or format of that information, that individual, it actually applies to the personal data. It may be objective, it may be subjective. I'll give you a simple example. It is not just limited to individuals' public or private life. It's not something about my name or my driving license or my PAN card or my social security number or my passport number, which is the personal data for me. It's also about the IP address that I'm actually using at this point in time on my laptop, or I, the websites that I visited today or any time before, that too also can identify me, because GDPR says it can identify the natural person, then it is also a personal data. So IP address, cookie information, any other paper records, or I can give you one example that is very well famous in the world of privacy. Let's say I have a car, and car is related to me. Car is actually not a natural person. But if I take this car to a garage and I repair it, and the garage person makes a bill for me where my name is written, but it's all about the bill for repairing my car. And if that bill will be used anytime in the future to identify me, okay, this man was having this car and he took this car to this garage to repair this, it actually identifies me. So it is again a personal data for me. If we process any CCTV footage to understand a natural person, that video recording will also be a personal data for that individual. So the definition of personal data is broadened in GDPR, and it was not the case with data protection directive before. And let's to be very clear here, we have something called personal data, which GDPR talks about. We have something called PII, personally identifiable information. These are two different things. Personally identifiable information has a very limited scope, whereas personal data has a very broadened scope. And that's where GDPR talks about personal data. Yeah, so it's all about, we discussed these terms I gave you the example of car, and I also gave you this example of CCTV footage. So all these 4 building blocks we discussed, even it applies to dynamic IP addresses. If someone argues that, okay, see, my IP is not static, it's a dynamic, it can change, but dynamic IP can also be a personal data, because the DSCP will have information that, okay, this particular time duration or this day, this IP was assigned to this MAC address, and through that MAC address, they can identify my computer, and through that computer, they can identify me. So this is all about relating to me. So it's my personal data. I mean, by explaining this all, you should understand it's very tough now to say that what is not personal data. Yeah, so we talk about this point that GDPR applies to the living individual, living natural person, and not the disease. But yes, individual member states have their own calls. If they have any regulations where they protect the personal data of disease, then GDPR respects those. And here are some of the terminologies we have. We need to understand this in GDPR: controller and processor, very famous terminologies. So the controller is the one who actually determines the purposes and means of processing personal data, who actually collects the data, understands the requirement of having the personal data, determines the need and means of processing that personal data. That entity or individual will call the controller. The controller will have different processors, to whom he can give the personal data to process that data on behalf of the controller, and those are called processors. So processors will process the personal data according to the directions that processor will receive from the controller. So in many of the cases, processors are not the decision makers, but they are binding to the directions that they will receive from the controllers. And I can give you a simple limited example that we have third party in IT world, like we have third party clients, we have third party contracts, and in case if we have some personal data that we have collected for some requirements and we are giving it to our third party contractors to process it because we require some information out of it or our business needs something out of it, then we being a controller and the third party who will process the data on behalf of us will be the processor. So then we have two more terminologies. Data subject. Data subject is all about a natural person, identified or identifiable natural person. He should be living individual and not diseased. And supervisory authority is actually the data protection authorities. They have different names in every member state. In UK, they call this as Information Commissioner's Office. Belgium, they have this as Privacy Commission. They they are they are actually the authority in the member state and they are responsible to monitor the compliance with GDPR. So in case if we have a data breach and we need to report that, we should report this to supervisory authority of that country. Let's say if we are processing the data of European individuals, maybe from Belgium, and then we found that okay there is a data breach, then we should reach out to Privacy Commission in Belgium to inform that. Then we have quick revision what we talked about GDPR, because these are like quick terminologies, and then we'll go for some details, and I think we don't really need to revise it because we just went through it. So it's like a quick revision. We can, in case if you have any questions, we can talk about it, or we can go to the next slides.
As this is the live interactive webinar, so we can expect some questions from the participant. Yes, Sid, can I have your question on chat box? Or you can unmute, you can speak. Sid, you can unmute, you can speak.
Hello.
Yeah, Anuradha.
Yeah, actually, I wanted to ask, like, you said that PII has a limited scope. So can you please give me an example, like what examples would come under PII? Because personally,
Yes, sir.
what
Right.
actually generally what I think is that personal data we only thing name, like you said, it's not only name or the date of birth or PAN number kind of thing. Personal data is something related to the example you gave of car and everything, which was very new to know. So what comes under PII actually?
Yeah, thank you, Anuradha, for the question. So when we talk about PII is actually the direct personal data of a natural individual. PII is a terminology that we use across the world to identify a person. When we say that, what is PII? PII for me is my name, my telephone number, my passport number, my PAN card, my social security number, my the numbers or the information that directly identifies me as a person is my PII. But when it comes to explaining the personal data of GDPR, it's not limited to directly identifying a natural person. It is, the scope is broadened and it is expanded to a certain level where information which can identify later, I mean it, where a person can be identifiable. It is not identified, but it is identifiable, is also a personal data. And I can give you a quick example here that we have a CCTV camera installed in our workplace. So this is not a personal data for anybody, because we are actually crossing in front of this camera many times, and it is not something that okay installed to track me or track you or track anybody. Yeah, So it's not a PII, but it will come under the scope of GDPR if this camera in the future will be used to identify, or sorry, the footage that is taken from this camera will be used in the future to identify somebody, maybe to identify me or to other person, to you or anybody who crossed from that camera at particular time. Then the intent is changed. The intent is now this footage is being taken to identify a natural person. So now it is comes to the personal data of that natural person. This is not PII, but this is a personal data, and this is in the scope of GDPR. I hope this answers the question.
Yes, absolutely.
Thank you.
Yes, with hello.
Yeah.
This is Sid, and I just
Yes.
wanted to ask you. You just explained me this thing, and you cleared a lot of doubts on this. Thank you very much for this webinar, first of all. And then, yeah, the question is that when it comes to the rights of the data subject, okay, so how do we consider the rights of data subject if in terms of systematic monitoring of the person, so do we, for example, CCTV, does these data subject rights also comes to picture when we're talking about these personally identifiable information which you said?
Yeah, exactly. So data subject rights, we are going to talk about it in the next slides. And this is very important topic. So we have data subject rights defined in GDPR, and then we have some lawful data processing principles also. And then if we comply to those, we can process the personal data. So GDPR is not restricting you or anybody to process the personal data, but GDPR is there to set some boundaries, to make us ethical, to make us responsible, and to make us transparent while processing the personal data. So we'll talk about those rights in the next slides, and I think this will explain your question there.
All right, thank you. And I have asked one more question on the chat. Okay. The question is that does processor need to communicate to the supervisory authority or the controller for who it is processing?
No, the controller should always communicate to the supervisory authority. In case of a data breach and it is being identified by the processor, then processor should communicate to controller, and controller should inform the supervisory authority. This is the steps. Yeah.
Okay, thank you. I think you just mentioned earlier that the processor has to communicate if there is a breach, but I think controller should do that, right? Okay.
Yeah, controller should do that to supervisory authority, but processor can inform the controller. But processor cannot inform directly to the supervisory authority because he is not the decision maker.
Yes, and that should be communicated in the agreement, right, to the processor, that if there is any breach from the processor side, the processor should communicate to the supervisory authority, to the controller. So there should be, there is a 72 hours window. So the 72 hours window is for the complete breach or for only the for the controller. Okay.
Yeah, so I will talk about that point because there is one slide. So quickly to answer your question, from the time when we identify the breach, let's say a company identifies a breach that okay they have they experienced a data breach, from that time to 72 hours is your window. Before 72 hours you should inform to the supervisory authority.
All right, thank you, Shanaz.
My pleasure. Yeah, so let's move on. We have a little 25 minutes more, so quickly we'll wrap it up. Yeah, so here we are talking about territorial scope of GDPR. There are three terms that regulation talks about, but in a nutshell, to understand this very well, let's not go to the language of law, but in a simple words, GDPR applies to all organizations across the world which controls or processes personal data of data subjects who are the EU citizens or residents. Not even just citizens, even the residents are there, and you are processing the personal data of EU citizens and residents, and you are part of anywhere in this world, GDPR applies to you. This is the territorial scope of GDPR. When we talk about material scope of GDPR, you have data electronically saved, or you have manual processing. Yeah, so a little bit. Yeah, so the material scope of GDPR, is there any question here? Yeah, so Sanjay, to answer your question, does that include non-EU companies that process EU data subjects? Exactly. So any company in the world who has personal data of EU data subjects, GDPR applies to them. This is the material scope. Across the world, it applies to them. If you have, and if you are processing personal data of European nationals or residents also, not just citizens, but residents also. And material scope of GDPR, it applies to the electronic form of data as well as it applies to the manual processing. It's automated if you have automated means, or manual processing if your data is stored in electronically or in the files in the shelves, and those are personal data. GDPR applies to the all forms of data. So the material scope covers everything. Then going further quickly, yeah, so here we're talking about some data processing principles of GDPR, and this is where the holistic understanding of GDPR comes into our mind. Let's go through all of them. There are 7 data processing principles that GDPR talks about. Let's go to all of them quickly. The very first thing or first principle that GDPR talks about is lawfulness, fairness, and transparency. And I think I told you earlier, this is the language of law. It's not a Boolean algebra. It's not something true and false that what we have in engineering world or IT world. It's a law. So when we talk about lawfulness, fairness, and transparency, we should understand these terms, and we'll talk about lawfulness in the next slides, what exactly it is. Fairness and transparency is something that we should take the call. No, when we are processing the data, it should be fair processing, and we should create the transparency as well. Purpose limitation. So the data should be collected for the specified and explicit purposes only. I can give you a simple example. When we wanted to understand the individuals of one European countries for the age between, let's say 20 to 30, 30 to 40, 40 to 50, then we should not ask their date of births. If we should ask their date of birth, then we are asking their day, their date, their month of the birth also, which we don't really require it. Our purpose is to identify their age. So simply we can just ask them their year of birth, and this will actually the enough information for us to identify their age. So this is something we should understand, that okay, we should collect the data as much as we require it. And that's again, we talk about data minimization. We should not collect the data which we really don't require it. We should collect the data only that which we require it. Accuracy is when we say that we are collecting the data, that personal data should be accurate, should be should be accurate and should be having a storage limitation also. If I collect the personal data for some company business requirements, then I should know how long I require this personal data. So the data should have an expiry period. Let's say I need this data for another 6 months, then after 6 months the data should get deleted from my all records. That is called storage limitations. We cannot collect and keep this data as long as we require it. Whenever our purpose is done, we should delete this data. Integrity and confidentiality, where the GDPR talks about pseudonymization or encryption to protect the personal data. So when we have a personal data, we should not keep that personal data plain without any protection, but we should encrypt them, and we should protect them with some level of encryption, or we should pseudonymize them, so that in case of the data breach, even if the data is hacked, then it will not have any benefit for the hackers. And then finally is the accountability. Data controllers will be accountable for the personal data that they will collect and store and process. Either they will process or they will give it to the processors to process the data, and the data controllers will be accountable for that. So these are the 7 data processing principles, and if you go through all of them 7, then you can understand that okay, GDPR is not talking anything new. It's talking about the company should be ethical, transparent, and they should be responsible or accountable for what they do for when processing the personal data of European citizens or residents. So let's talk about what is lawfulness here. When we say that lawfulness, there are so many lawful basis of processing data under GDPR. And here I can explain you the very common understandings. If we have a consent from the data subject that okay, I want to process your data, and the data subject is agreeing with that, then we can process the data, personal data of the data subject, and it's lawful for us to process the personal data of that individual. Let's say if we have a contract also, we have signed the contract with some European entity or European data subjects that okay, as part of this contract we will process your personal data, then it is a lawful basis for us to process their personal data. If we have some legal obligations where we really need to keep their records because it may require in the future in the court for any legal matters, then this is one of the lawful bases where we can keep or process their personal data. And GDPR is saying that okay, you can do this for these reasons. If there is some vital interests or public interest, let's say like for example a VVIP person is there, then we need to really protect him and give him safety, and then we should keep his personal data, and we should, this is something like for the benefit of that person. Similarly, if we have someone who is actually harming us, like for example criminals, terrorists, or some other folks who actually can cause the harm to us, then we really need to keep and process that personal data, and this is also lawful for us. So it's like, it's not something that completely restricted. No, they are lawful basis where you can go ahead and keep personal data and process the personal data, and GDPR talks about it. And also there is a legitimate interest, where your business has some interest, and it's not something that you have a concern with that individuals, but it's like a core of your business, and if you do that, then you will earn the profit. In that case, you should or you can process the personal data, but then at the same time you should answer this question, how you can do that. Because if you are processing the personal data, then there are different data subject rights, and we'll talk about it, that how we can process their personal data. So let's talk about that. Know your rights, so data subject rights. And before, I always begin this discussion with a quick joke here. So before we go and understand what are the data subject rights, have you heard this GDPR joke about the man from Europe? Anybody knows about GDPR joke from the man in Europe? Okay, let me explain this. Then yeah, so it's a joke, of course. And unfortunately, I can't tell you because the data subject hasn't granted consent, and I have no longer legal basis for processing. So I didn't get the consent of that man from Europe, and I don't have any legal basis also at this point in time to tell you that joke. So this is again a joke that, see, I can't share that joke because I don't have enough rights under the GDPR to share this information with you. So this is the data subject rights, and let's talk about them. Okay, so this is welcome to DCDSR. Here we have data subject rights. There are 8 rights, important rights that we should talk about here. Let's go through them quickly one by one. Right to be informed. When we process personal data, when we process personal data of any European individual, then they have the right to be informed. We should inform them that, okay, your data is with us, your personal data is with us, and we are processing this. If we inform them, we should also give them the right to access their personal data. So we should also create some interface for them so that anytime they can access that personal data through any means. And they can understand that, okay, their personal data is accurate or not, and not something like that. Similarly, there is a right to rectification. Right to rectification means, in case at any point in time, if data subject thinks that, okay, this information, this personal information is not correct, or it is changed over a period of time, then they have the right to access that personal data, and they can change that personal data. And not necessarily they can inform you, because they are changing this personal data in your interface, and they should get this right to do that. At the same time, they have also right to erasure. So in case if they want you to completely forget their personal data, you should erase that personal data from all your records, then they can initiate this request, and you should delete their personal data from all your records. This is one of the data subject rights that they have. Another thing is right to restriction of processing. In between, anytime if a data subject thinks that, okay, they want you to stop processing their personal data, but you can keep that personal data, but don't process it, then they can ask this information to you. They can demand this to you, and you should stop processing their personal data. The next right is right to data portability. So you should give them a API or a kind of interface where they can upload their personal data, and then they can read their personal data in any forms, in any kind of device. So this is the right of data portability to them. And then right to object is also, they can also object that, okay, see, they are not asking you to stop it, but they are objecting, they are arguing with you that, okay, see, now this personal data you are processing, but our contract or our concern says that you should not process this personal data. So they can object, and you should hear that objections. And then they can also say that you have some automated means of processing their personal data, so you should not go to the automated means of processing their personal data. You can process their personal data for some manual things, but when it comes to automated processing, they can object. They can say that, okay, don't process it for the automated processing, and then you should comply with that as well. So these are very interesting and informative and important points, and a very important topic in GDPR. And organization who needs to comply with the GDPR, they should comply to all these data subject rights. And if you carry a website, or if you carry some different means of having where you can process the personal data of European citizens or residents, now you should think about how you can apply all these DSR or data subject rights, so that your website or your other means of processing should comply with the GDPR. If you have any quick questions here on this topic, or we can just move further.
Sainawaz, this side Vishal, I have a question here.
Yeah.
So,
sure.
you in this you have not mentioned the consent part. Is where the consent part of user is coming in this GDPR? Like, if I am visiting to hotel, if I am visiting to any site as a customer, so as a controller or as a website owner, can I put the consent type of thing on the site or on a hotel, where I can mention that I can use your data, your personal data for this many time, or this.
Right. Yeah. So Vishal, to answer your question, consent come first, and DCR or data subject rights comes later. So first you need to have a consent, and when you take the consent, you will get the lawful basis to process their personal data. So consent actually gives you the lawful basis to process their personal data. But when you get the consent, it's not something that everything is ended there. So after getting the consent, you have now lawful basis to process their personal data. But when you started processing their personal data, then their rights comes here. And as part of their rights, we are talking about these data subject rights. So now, you took the consent, you are processing their personal data. So now your data subjects have these rights. They can ask you to rectify their data. They can ask you that, okay, they need access to their data. They can ask you that they should be informed about it when you process their data. They can ask you that in case if they are asking you to forget their data, you should do that. So all these rights comes after having the consent.
Correct.
Right? Yeah. I hope this answers the question, Vishal.
Yeah. Yes.
Thanks.
Thank you.
Hello.
Hi.
Yeah, hi Shanawaz, this is Vivek. I have one question.
Yeah, sure. Yeah, please.
Yeah, so consent part only. So consent has to be taken for the non-active data with the retrospective before 25th also. As for example, I have the data of many of our vendors or the users with whom which we are not having active engagements. But for that also we have to take consent to keep their data in our records or in our databases.
So to answer that question, Vivek, if you store the personal information of European citizens or residents, and if you are not processing it, again it is actually coming under this GDPR scope. So it is not necessarily that you should always process it, but as far as you are storing it, then that data should comply with the GDPR. So if you have some data which are, which you think that it's not active, it's idle, you're no more using it, then you should understand the data minimization principles there. You should ask this question that, okay, if you really require that, if you really require, if you don't require it, then just delete it. But if you require it, or if you can say you may require it in the future, then you need to go and answer this question that how you can process it. And when it comes to asking this question, how you can process it, that's where you need to comply with the GDPR to understand this. But but storing the personal data which is not active, you should also comply with the data subject rights, because their data is stored with you and they can ask you anytime to access their data, what you are storing, and they have all different 8 different data subject rights, and one who actually stores those information should comply with that data subject. This is what GDPR talks about.
Okay, thanks.
Thanks, Vivek. Yeah, I hope this answers the question, right?
Yeah, but my just point was, do we need to take consent for storing the data as well for
Yes,
for
yes.
non-active engagement?
Yeah,
Okay.
so the consent is taken when collecting the data. So after collection, you can, while taking the concern, you can define that, okay, you may process this data for these reasons, or you can just simply collecting this data. So while collecting the data, you should take the concern, and then you can either process it or keep it.
Yeah. So the data which I have before 25th of May. So after 25th of May, yes, I will be taking the consent at the time of collection of the data. But the data which I have before 25th of May, which I have lots of data with me. So for
Yeah.
that also I have to take consent retrospective.
Yeah, so it's actually a call for you to take, because you took this data before 25th of May, before the GDPR enforcement date, and now you're
Yeah.
actually in the era of GDPR. So to understand this in a very simple way, at this point in time, if you have a data breach and that data is getting compromised, then you are actually coming under the scope of GDPR. So
Yes.
the best way is, if you have this data, you should inform those data subjects and let them and get the consent from them, or get some lawful basis to store that, to keep storing that data.
Okay.
And this, yeah,
Yeah.
I hope this answers. Yeah, so we
Yeah.
have
Thanks.
just a couple of minutes, I think. Can we just cover a couple of important slides? Yeah, so before, just to understand what we discussed, here we have one cartoon where one lady is talking to another person. Before I write my name on the board, I will need to know how you will, or how you are planning to use that data. It says this cartoon actually talks about which data subject rights. It is right to be informed, right? So the data subject is demanding that you should let me know how, or how you will plan, or how you will process my personal data, and this is my right, so that then I will actually give you my name, or I will write that name on the board. So this is right to be informed. There is one more cartoon that I added here. Is a lady is talking to a gentleman. Hello, I would like to be forgotten under GDPR. Certainly, madam. Okay, it's done. And I would also like to know, sorry, madam, you don't seem to be in my database. So this scenario is something talking about right to be forgotten. So right to be forgotten means if we are deleting the data of this individual, we should delete it from all the records. We should not have it anywhere, and this is something GDPR talks about. Uh, GDPR fines. So 20 millions, 4% of global annual turnover from the prior year. This is the maximum fine of GDPR. There is also minimum level of fine, where where it talks about 10 million euros or 2% of the global annual turnover. So for all the multinational companies, if you talk about 4% of their annual global turnover, it's a huge amount. It's a huge amount. For a simple normal firm who is not multinational but actually, setting up and having some expansions, and is actually a what you can say, mid-level firm or something. 20 million is like either they'll make it or they'll break it, right? So this is actually the case, so it's really important topic. If we have a data breach, then we should deal with these all fines and penalties. And for the small players, it's all about like either you can make it or break it. It's a game, right? So this is the biggest concern with GDPR. But GDPR is not here to impose the fines. GDPR is here to make us ethical, transparent, and accountable. This is something I told you before, and I'll keep telling you. This is not about all about fines, but it's all about helping us to make us ethical, accountable, and transparent. So, Prab, we have more time, or we can?
I wish we could have more time. So how many slides are left?
I think 5-6 slides are left.
Okay, can you wrap up in next 10 minutes?
Yeah, so I think I'll go, quickly. I'll talk about that loyalty card example. I'll take 5-6 minutes there.
Sure.
So after this slide, I'll just go there. Yeah. So here we have data breach notification. We got one question here that 72 hours we have to, within the 72 hours of data breach, we have to inform the supervisory authority of that country. The moment we identify a data breach, from that time our clock gets started, and we have now 72 hours to collect the data, to investigate it, and to understand really this data is breached, and then to prepare for litigation, and then to communicate to the supervisory authority. So now, because of this all evolving cyber threat landscapes, the data getting breached, we don't know in the dark web how fast, how quickly, and where this data will get used. So because of that, this type of regulations are coming in the modern world, where the time limitation is also there. If we are not complying with the 72 hours, then again we have to go for the GDPR fines. Yeah, and then I need to talk about one quick example here. So far what we discussed about GDPR, let's take one quick example to understand this. And this is a loyalty card example. We have in India so many retail stores like DMart, one of the famous stores. Reliance, they have stores. More, they have stores. Star Hyper, so many things. Like you can simulate any kind of these stores, or Shoppers Stop, or Lifestyle, or anything else. So they have, let's say, any of your favorite store have loyalty card, and they wanted to give you this benefit because you are the regular customer there. So we'll simulate this in GDPR or without GDPR. So let's say like we don't have GDPR, then as part of the loyalty card form, your retailer will ask you to fill this information in their form, because you are applying for the loyalty card, and they will give you that loyalty card, and you will collect the points for the shoppings that you do at their store. They'll ask you name, date of birth, address, mobile number, email, signature, financial information. I highlighted some of the fields in yellow. We'll talk about them. Now, then, after collecting this information, they gave you the card, and then they have some personal data from you, because now they started tracking you. You are coming to that store, you're purchasing something, and then they started understanding your behavior, what you are purchasing from their store. So in a month time, they started sending some brochures to your address to let you know their monthly offers. So this is maybe, this is the legal purpose. They are actually marketing some of the offers and products, and it's actually can be of your legitimate interest, and they're okay. I mean, they are doing it, and then you don't have
Yesterday.
any issues, and you took no actions. So it's okay. I mean, you are thinking that we are benefiting from this action. You are getting some monthly brochures, and then you may take some decisions in case if you want to buy something from their store. But then when they started monitoring your shopping behaviors, you discovered after 6 months that the offers that they send to you and to your neighbor, they are not same. Your neighbors are getting different offers from the same store, but you are getting something which is very different. So it means that actually they are tracking you as a single person, as an individual. They started monitoring you, that what you are buying from their store. So it could be something which is related to your personal things as well, and you are buying from their store. But did they ask your consent to do that? Don't you think that you should have been asked for this? But then we don't take any actions, because we started feeling that maybe this is something which is very personalized offer for me. So what will happen? Let's say, like, what will happen next? Let's say, like, having this all information, they'll be having one data breach, and your loyalty guard information as part of their data breach got compromised. Now you don't have GDPR. You call that company, but then they were not having any data subject rights information. They don't know how to give you the access to your personal data. So they will simply say that, okay, we can't share any information to you on phone, you know I'm sorry, and we cannot help, something like that. You will hear these stories. And then, because this data breach, now the hackers will have your personal information, your financial information, and at the same time, you are struggling because you don't have any law, you don't have any regulations to support you for your own rights. Your personal data is breached because you were part of this loyalty card offer. So to avoid this helpless situation for any individual, how GDPR will help? Let's check this. With GDPR, your favorite store is obliged to apply the data minimization principles. So they will think twice before collecting your personal data, that how much data they really require it. They will ask this question, whether date of birth is really required. Why should I collect the date of birth information? Why should I collect the signature? Why should I collect the financial information? Why should I collect the credit card information of that individual? Right? So these all information they will ask. And in case if they don't really require it, they will avoid using this information. So let's say, like, having a data breach, if they are not collecting your financial information, because GDPR is protecting you. So in case, your other information is getting shared to the hackers without financial information, you will be having some relief, right? Okay, anyways, my credit card is safe. I don't really have to worry about it because they are not storing my financial information and GDPR is there. Here you have, in monthly brochures, they will not send this monthly brochures until under the GDPRs. They will ask your consent. They will ask your data subject rights as part of the data subject rights. They will give you all the rights. Okay, you need to get informed. You need to get forgotten. Everything will be there. So you don't really have to worry. You will have your own control on your personal data, and you should not be really worried about any data breach because you are the controller of your personal data, right? And then for shopping behavior where, again, they'll have to go through the concern. And finally, when it comes to breach notification or breach data breach, they'll have to notify the supervisory authority in 72 hours. As part of the GDPR regulation, they should pseudonymize the data. The data should be encrypted. So all of this, if GDPR is there and the data breach is occurring, then the information that the hackers will get will of no use for them. They'll not get the financial information. Even if they get any personal information, that will be pseudonymized, that will be encrypted. It's very difficult for them to, get anything out of it. So, this is how GDPR will protect us in our real life, in our real business world. And that's why GDPR is there not to impose any fines, not to put more restrictions, but it's all about to help us live with complete privacy in this technologically advanced and rapidly changing world. If we have any questions on this example, we can talk about it. Okay, so I think we are 15 minutes more. So
Shanawaz, actually the session is from 4 to 5 p.m. So it is not 4 to 6, it's 4 to 5.
Yeah,
we have
that's
covered
right.
more than 15, yeah. So I think it was really so any of the topic left in this GDPR? You have completed from your end, right? All the points?
Yeah, a couple of points are left, but they are little advanced, so
Okay,
not
no
really.
issues. No issues. So guys, any questions from anyone? Any attendees who would like to raise any questions
Yeah,
related to this?
just
Yeah.
yeah. I have one question only on the
Mm-hmm.
PIA.
Mm-hmm.
Even though it hasn't covered in this session because of time constraint,
Mm-hmm.
just one clarification I need.
Mm-hmm.
Do we need to do DPIA only in case we are processing a special category of data or any data?
Okay, that's a good question. Let's talk about the PIA quickly.
Mm-hmm. And one more question is there from Mr. Sanjay. Is like in Sanjay, can you unmute? You can speak because it's better that you can if a
Hi there.
yeah Sanjay, yeah.
Okay, so the question is, say I'm in Australia at the moment. So say for instance, Australia has its own privacy law and GDPR has an adequate status. And I'm assuming with that adequate status, it's the most comprehensive one in worldwide. So correct me, I stand to correction to this. Now, what if an Australian entity, an organization wanting to perform a privacy compliance exercise, and if they do a GDPR using the GDPR framework, would that cover them for the would that cover them the compliance for the Australian laws as well? Of course, I do understand that probably you may or may not be aware about the Australian laws, but where I'm coming from is that assuming that GDPR framework or the guidelines provided by them is the most comprehensive one.
So it's a tricky question, Sanjay. And to answer this, actually, I mean, it's a simple understanding that we should have it here. GDPR is the law for Europe, and it's not for Australia. So to comply with GDPR, it means you are complying the laws of Europe. Australia may have some laws which could not be, as part of the privacy, which could not be included in the GDPR. So if you miss that, then it will be a problem. So
Okay.
Complying the GDPR doesn't really mean that you are complying all the regulations and privacy that Australia is talking about. You should really define this.
So basically, we need to compare both of them and go with the most comprehensive one to cover all angles. Is my understanding correct?
Yeah, exactly. So I can tell you one quick understanding here. So GDPR talks about 72 hours time frame given to all the organizations to report their data breach. Australia may have some different time frame, and that time frame can be less than 72 hours also, right?
No, actually, I believe Australia has got a limit of within 30 days you have to report. And that too, it covers like, say, for instance, an organization should comply with the Australian privacy laws who has a turnover of $3 million per year. And in fact, anything below $3 million, they are not even, they are not required to ensure that they are compliant to it. So it's kind of tricky. I'm sorry, but I may not be thoroughly understanding the local laws over here. What I understand is from the skin level, but probably I can frame the question in a different manner. I can say within India itself, if an entity in India had to do a privacy exercise, replacing Australia, replacing the question about Australia, how would it look like?
Yeah, so if an entity in India and they have personal information from Europe, from European citizens or residents, then they should comply with GDPR. If they don't have,
correct.
But if they don't have,
sorry about that. You can go first.
Okay, so if they don't have any of such information where they are, they are processing personal information of European citizens or residents, and they don't keep this information also as part of their business, then they don't really need to comply with GDPR. But then maybe some local laws, if India has in privacy, then they should think about that.
Okay. What if they were GDPR compliant, not processing, and they do not process EU citizens, they were only processing Indian citizens? Is there a particular Indian privacy law that actually is more stricter than the GDPR laws? If you get what I'm trying to say.
Yeah, to answer this question, GDPR is the most comprehensive and strict regulation in privacy as of today. So there is no law as of today anywhere in this world which can compete with GDPR.
So if we are GDPR compliance, that means we do not need to worry about the local laws, because that would actually, we would be covering all angles. Is my understanding correct in that?
I mean, to answer this question, I would say yes, but at the same time, I would say that you should also get the thorough understanding of your local law and to do a double check that okay, you're not missing anything there.
Okay, thank you. That clarifies it.
Thanks, indeed.
Okay, so I want to ask one question, Shanawaz. That, as you see, just want to comment. It's not a question. Just want to comment that privacy law in India It's a fundamental right right now as per Supreme Court. So just a comment on that. Is it possible in the Indian scenario to have a privacy law, and how challenging it would be implementing and enforcing the privacy law? Thank you.
Yeah, so Sid, see, I mean, as far as I know, we have some privacy laws. We have even privacy certifications, and we can talk about this after this webinar. And also, the recent news says that Asian countries, including India and China, are getting serious about their privacy. So the existing laws will get enhanced because there are a lot of lawyers. They are actually working in this field now, and we should be hearing some news in the future where we will start hearing the news from our parliament that see maybe these type of laws are getting imposed, privacy laws are getting imposed, because this is the need of the hour. And you know, the way that cybersecurity threat landscape is evolving, this is something required, and India will definitely come to this point in the very near future where we'll see many privacy laws will come. So at this point in time, to quickly answer this question and close this, doesn't mean that we don't have privacy laws. We have privacy laws. We have also local privacy certifications as well. And we'll talk about this because this is not in the scope of GDPR, but we can connect later and we can talk about this.
We need to wrap up this
Hey,
now.
Shanawaz,
Yeah. Any other questions, Anil?
just one question.
Yeah.
Yeah. Yeah. Are there any exclusions to this, privacy, the law? I mean, in the sense, are there any federal or any legal or a government, personals can interfere with, client personal information without the consent of the client or a customer?
Yeah, so there are legal bases, of course. If it's actually something that really requires to track that individual and we have some legal basis, then yes, we don't really need to take the consent and we can track that individual and get that personal data, record and process it. So this is something GDPR talks about it.
Actually, we are running out of time. We have another session that's supposed to be scheduled for 5:45. If you have any questions, you can drop your queries at sales@infosectrain.com, or Shanawaz can help you with all those queries. So I'm going to type that email ID.
I only need to clarify on Mr. Sanjay's question actually.
Yeah.
Mr. Sanjay said that it is related to Australia. Like what my understanding is, like GDPR is for your European countries, right? So if Australian data is related, so what I understand is that they need to comply with Australian laws. What I understand, not majorly with the GDPR. GDPR is overall comprehensive for European countries. So is I am right over here for this particular thing that comply with Australia?
Yeah, so Anuradha, to answer that question, actually Sanjay was talking about a company who is in Australia who is having the personal information of Australian citizens as well as European citizens. Yeah, so in that case, the GDPR applies to them.
Okay, both applies, GDPR also and the local application of the law.
Yes, because the territorial scope of GDPR says that any company across the world, if they have or they keep or they process the personal data of European individuals or residents, then they are in the scope.
So we need to understand here is when it comes to GDPR, it's basically a primary to give control to the citizens and the residents over their personal data, and to simplify the regulatory environment for the international business, which is unifying the regulation within the European Union. Correct me if I'm wrong, Shanavas. Because it's
yeah, this is correct, Prabha. Yeah, this is correct, exactly.
Because whatever the customer data, it is specific to the European boundaries and all that, it need to be comply with the GDPR. By end of the day, the purpose of GDPR is to protect the European data. Either it is basically managed by the company reside in European boundary, or it is outside. So by end of the day, they have to follow those directives. It is by enforceable, because it also address the export of personal data which is outside the European Union and other areas. So it is overall objective is to control the data of the citizen of European Union. How are you going to manage that? So thank you so much, guys. We will going to record this session. We will be going to record this session, and we are doing that right now. I think Shanavaz is going to export and we will upload in the YouTube. So if you have any other questions, because we are also planning to come up with the certifications for the GDPR by a PCB and IGC, and the Shanavaz will be the instructor for that courses. So we are expecting more and more webinars in future. We are planning for the next webinar will be on CYSA, CompTIA, and Pentest Plus. Along with that, we are also planning to come up with some business transformation with digital forensics. As the InfosecTrain promised, they will do more and more information security and governance webinar. Thank you for your time. Shanavaz, thank you for your time also. In weekend, you have take out your 1 hour 30-minute session for this webinar. And I would like to thank all the attendees who joined this webinar.
Yeah, thank you, Prab. Thank you all.
Please
Have a
share your
great week.
feedback.
Thank you, Prabhu.
Welcome. Please share your feedback, guys. It really motivates us and it improve our upcoming webinars also. Thank you.
Thank you.
Thank
Bye.
you, Prab.
Bye.
Thank you.
Welcome.
Thanks.
Thank you.